All right. Good morning, everyone. Today we have an application hearing in the matter of CFI-047 before His Excellency Justice Ali Al-Madhani. The claimant is represented by Evershed Sutherland, lead counsel Lawrence Page, assisted Rebecca Copley. The second defendant is represented by LPD Middle East LLC, lead counsel Nigel Hardridge, assisted by Kareem Nasif. And the second defendant is represented by Curtis Malik Prevost, lead counsel Serena Bosha Montalbano, assisted by Maria Ozolins. Thank you.
If you please the court, Patrick Dillon Malone from KBH. I'm here as a courtesy representing the liquidator of the defendant company, Totora, and we are instructed in relation to certain of the administrative aspects of the liquidation and have had some dealings, as you may know, with enforcement and with the court as matters have proceeded, particularly in respect of a number of employee claims. I'm simply here as a courtesy, Your Excellency, to inform you that the liquidator will not be participating in these proceedings.
Yes, I understand your position, and I think you are welcome as long as it is a public hearing, and as long as there is no objection from any parties to your presence. I just wonder why you're sitting in the front seat only. And you dressed formally as well.
Yes. Well, I believe it was a mark of due respect to the court.
Well, thank you very much.
Thank you.
Well, I understand we are dealing with 2.5 applications today. 2 applications for contest of jurisdiction before this court by 2 of the defendants. And there is a contest by the claimant for the 4th defendant to come on record at this time and submit the defense and even want of jurisdiction application. I don't have problem with the order, but we might start with Ms. Al-Khalifa.
Thank you, Your Honor.
Serena, you may start.
Thank you, Your Honor. I'm Serena Bosha Montalbano from Curtis Malik Prevost, and I represent the applicant Sheikha Rania Ahmad Mubarak Al-Khalifa. in her application seeking dismissal of the claim filed against her by the Commercial Bank of Dubai, and an order that the BIS courts do not have jurisdiction to hear the claimant's claim pursuant to RDC 12.1 and Article 5A of Law Number 12 of 2004 as amended, the Judicial Authority Law. I will refer, Your Honor, to my client as Ms. Al-Khalifa, if this is fine with the court, as there was some confusion apparently regarding the proper labeling of the defendants due to the fact that the claimant indicated that Ms. Al-Khalifa in the claim form as the third defendant and in the particulars of claim as the fourth defendant. The registry attempted to clarify this confusion by an email in January 2018, where the registry instructed the parties to refer to the defendants as per the claim form. However, the claimant continued to refer to Ms. Khalifa as the fourth defendant, including in the first witness statement of Ms. Rebecca Copley and the amended witness statement. Therefore, to avoid further confusion, I'll refer to the third defendant as Ms. Al-Khalifa. If I may give...
Well, in the bundle before me, Sheikh Al-Khalifa always referred to as a second defendant. And most of the bundle, in all of the bundles before me, and most of the document, she is referred to as a second defendant.
Well, Your Honor, in the claim form, she is referred to as defendant number 3. The claim form, you can find, Your Honor, a copy in the application bundle tab 1, page 1.
Yeah.
And then in the particulars of claim, same bundle.
So you're looking what hearing bundle? What's it? Behind tab what?
Tab 1 is the claim form, Your Honor, page 1. Ms. Al-Khalifa is defendant number 3.
Yes, yes, all right, I see that, yes.
And then tab 2, particulars of claim, Ms. Al-Khalifa is defendant number 4.
Oh, I see that, yes. So the registry email confirmed that she is the third defendant?
Confirmed that she is the third defendant.
And you okay with that?
I'm okay with that. However, in the witness statement of Ms. Rebecca Copley, Ms. Al-Khalifa is again referred as the fourth defendant. Therefore, for the reason in our skeleton argument submitted last week, we refer to Ms. Al-Khalifa as Ms. Al-Khalifa as opposed to third or fourth defendant.
Can you remind me where I found Rebecca's witness statement?
Yes, Your Honor. It's the amended first witness statement is tab 5 of the application bundle.
What's behind tab 5 is application notice, not a witness statement, at least in my bundle. And then fourth defendant application notice dated 4th February 2018.
I apologize, Your Honor. In my bundle and in the
Oh, you said you. Oh, sorry, your bundle. Okay.
Sorry, Your Honor. I'm informed that that was probably the bundle submitted by Mr. Ramadan Al-Rafai.
I have 3 bundles before me.
I'm referring to the bundle that has on the front cover application hearing bundle of Sheikh Rania Mubarak Al-Khalifa.
Yes, okay, I got this. Yes, I see. And so you seeking agreement between all parties that your client is to be called the third defendant. Is that right?
I was proposing, Your Honor, to call my client Ms. Al-Khalifa for purposes of this hearing, which is how we refer to the third defendant, Ms. Al-Khalifa, in our skeleton argument.
Well, I don't mind doing that, but I think for the future of this proceeding, it's good to be again, accurately numbered. Like can be remain third defendant.
Third defendant.
Yeah.
Thank you, Your Honor.
Right.
Thank you.
You may address your application now.
Thank you, Your Honor.
Unless there is any other housekeeping matter that any of the parties wish to address. No, please.
Thank you. If I may give a
Yes,
very...
how did you do this?
A very short background. As Your Honor is aware, this case was filed on 18 October 2017 by the Commercial Bank of Dubai, a public shareholding company incorporated under the laws of the United Arab Emirates. The address of the claimant's main branch is indicated as being at Al Ittihad Street, Port Said, Deira, Dubai. This is tab 5, page 99 of the application bundle. The claimant named the four defendants in the claim form: Totora Restaurant Lounge, a DIFC registered company currently in liquidation, Mr. Al-Sidani, Ms. Al-Khalifa, and Mr. Ramadan Al-Rafai. Ms. Al-Khalifa is an individual who is not resident in the DIFC. On 22nd November 2017, Ms. Al-Khalifa duly filed her acknowledgement of service and indicated her intention to dispute jurisdiction. On 7 December 2017, Ms. Al-Khalifa filed this application contesting jurisdiction on the grounds that the dispute does not fall within one of the jurisdictional gateways set out at Article 5 of the Judicial Authority Law, and that the parties have not opted into the DIFC court's jurisdiction. According to the particulars of claim, the claims against Ms. Al-Khalifa arise out of an agreement entered into on 6 April 2016 with the claimant, the guarantee. A copy of the guarantee can be found at page tab 2 of the application bundle, page 55 to 59, to the extent it pertains to Ms. Al-Khalifa. The subject of the guarantee is Ms. Al-Khalifa's agreement to pay directly to the claimant a certain sum in respect of a credit facility separately given by the claimant to Totora Restaurant and Lounge, the first defendant, the DIFC registered company, which we know it's currently under liquidation. The loan to the restaurant is governed by a separate agreement between the claimant and the first defendant only. That's the facility, a copy of which can be found at tab 2, pages 10 to 43. Ms. Al-Khalifa is not a party to the facility agreement. Ms. Al-Khalifa signed the guarantee at the Shangri-La office tower on Sheikh Zayed Road, Dubai, at the offices of Royal International Hospitality and Leisure Consultants. The meetings regarding the guarantee took place at Royal offices, and the meetings took place between the claimant and Ms. Al-Khalifa within the DIFC. This is the evidence given by Ms. Al-Khalifa in her witness statement, which can be found at tab 4, page 79. Ms. Al-Khalifa admits that the DIFC courts do not have a jurisdiction over the claims against her. The jurisdiction of the DIFC courts is defined in Article 5A of the Judicial Authority Law as amended, and a copy can be found of the law can be found in the bundle of authorities at tab 1, and the relevant provision, Article 5, is at pages 3 and 4. Under Article 5A1, the DIFC courts have exclusive jurisdiction if one of the 5 gateways is satisfied, Or under Article 5A2, the DIFC courts have jurisdiction if the parties agreed to opt into the jurisdiction of the DIFC courts. Accordingly, under the law, unless either Article 5A1 or Article 5A2 are satisfied, the DIFC courts do not have jurisdiction over the claims. Here, we submit that, the claimant and Ms. Al-Khalifa do not operate within the DIFC. They are not DIFC entities and did not specifically agree to the exclusive jurisdiction of the DIFC courts. We submit that the claimant's allegations in this case are not sufficient to establish jurisdiction of the DIFC courts. It is not even clear from the claimant's pleading and submissions on which specific provision of Article 5 the claimant ultimately relies on. In the claim form, the claimant stated that Clause 15 of the guarantee provides that the guarantee will be governed by and construed in accordance with the law of the United Arab Emirates, and that any dispute connected with the guarantees shall be submitted to the exclusive jurisdiction of the United Arab Emirates Court, and that it is therefore averred that the DIFC courts, being courts of the United Arab Emirates, has jurisdiction to hear this dispute. The claim form also states that further, or in the alternative, the jurisdiction of the DIFC courts is established under Article 5A1B of the Judicial Authority Law because the dispute is a claim arising out of or relating to the facility, a contract which was either concluded, finalized, or performed in the DIFC. Again, a copy of the claim form is tab 1, page 2 of the application bundle. Finally, the claim form states that Clause 15 of the guarantee provides that the right of the claimant shall not be limited to take proceedings against the guarantors in any other one or more jurisdiction, and that, accordingly, the claimant has the right to commence proceedings in the jurisdiction of his choice in its event. In the particulars of claim, the claimant's statement regarding jurisdiction of the DIFC courts against Ms. Al-Khalifa is limited to paragraph 11, where the claimant again cites clause 15 of the guarantees, and that's at tab 2, page 6. The claimant then expands its legal argument with respect to jurisdiction in the amended first witness statement of Ms. Copley, which was submitted in response to the application. And the red line provided by the claimant can be found at tab 5, page 86 of the application bundle. The amended first witness statement of Ms. Copley sets out at paragraph 26 that the claim falls within the jurisdiction of the CFI pursuant to Article 5A1B of the Judicial Authority Law, and states for the first time in the claimant's pleading that alternatively the CFI should exercise its discretion to accept jurisdiction pursuant to Article 5A2.
What do you mean for the first time?
It's the first time that specifically Article 5A2 is mentioned.
Okay.
In the claim form.
Isn't this the first occasion that they would deal with the jurisdiction? Because they just need to deal with the jurisdiction matter after you have lodged your application challenging the jurisdiction.
Yes, Your Honor, we submitted that in the claim form they refer to the guarantee and they referred to Article 5A1B, and then in the particulars they refer again to the guarantee. But in the witness statement, they refer for the first time to Article 5A2.
And what's the problem with this? If there is any legal issue with this? Are they refrained from submitting such argument at this time of the proceeding? You think?
We don't object to their argument that they can rely on. Yeah.
Then you go ahead.
Ms. Al-Khalifa submits that the claim against her do not fall within any of the jurisdictional gateways of Article 5A1. We can quickly exclude the jurisdiction under Article 5A1A. The claimant does not argue that Article 5A1A applies in this case, and in an event the claim does not involve the DIFC, and neither the claimant nor Ms. Al-Khalifa are one of the DIFC bodies or establishments. We can also quickly exclude jurisdiction under Articles 5A1D, and the 5A1E. Again, the claimant does not argue that gateway D and E applies in this case, and Ms. Al-Khalifa does not address them in detail as they clearly do not apply. I now address Article 5A1B, on which claimant relies. So, pursuant to Article Gateway B, the Court of First Instance shall have exclusive jurisdiction to hear and determine civil or commercial claims and actions arising out or relating to a contract or promise contract, whether partly or wholly concluded, finalized, or performed within the IFC, or will be performed or is supposed to be performed within the IFC, pursuant to express or implied terms stipulated in the contract. Ms. Al-Khalifa submits that Article 5A1B cannot establish jurisdiction, as this is not a claim arising out of or relating to a contract or promise contract partly or wholly performed, finalized, or partly concluded, finalized, or performed within the DIFC, or will be performed or supposed to be performed within the DIFC, pursuant to express or implied terms stipulated in the contract. So first, the guarantee agreement between Ms. Al-Khalifa and the bank was executed in Dubai, outside the DIFC, and no meetings took place between the claimant and Ms. Al-Khalifa within the DIFC. First witness statement of Ms. Al-Khalifa, tab 4, page 79. The guarantee, therefore, cannot be said, we submit, to have been partly or wholly concluded or finalized in the DIFC. Furthermore, claimant's argument that jurisdiction is conferred under Article 5A1B because the dispute is a claim arising out of relating to the facility, a contract which was concluded, claimants say, finalized or performed in the DIFC, and because still claimants allege the guarantee is related to the facility, we submit it's flawed because the relationship between the claimant and Ms. Al-Khalifa is not governed by the facility to which Ms. Al-Khalifa is not a party. The facility is a distinct and completely separate agreement between the claimant and the first defendant only.
Would you please tell me how this guarantee agreement can be settled in case Totora is performing in a very normal way?
Well, under the terms of the guarantee, the obligation under the guarantee is not contingent on the obligation under the facility. Clause 2 of the guarantee, a copy of which can be found at
page 50?
tab 2, page 55.
Okay.
So, clause 2...
You said 55?
Page 55, yes.
Yes.
Says that we unconditionally and irrevocably obliged to pay and settle under any circumstances and for any reason immediately on first demand from the bank and upon receiving a notification to our address mentioned therein, and then towards the middle, all monies, liabilities, obligation, and interest, whether certain or contingent. So we submit that, contrary to claimant's argument, to use a claimant's terminology, the guarantee is not parasitic on the facility. The obligation under the guarantee, pursuant to clause 2 of the guarantee, is not contingent on the obligation of the first defendant to the bank under the facility agreement. We submit that this is a freestanding obligation and the bank can request a repayment at any time and for any reason pursuant to the terms of the guarantee. And of course, all the arguments made by Ms. Al-Khalifa for purposes of the jurisdictional application are without prejudice to her reservation of rights to submit any substantive defenses in the future if necessary.
But what I'm saying, can we say that the paid-off of the debts by Totora in a usual way is a direct discharge of your client obligation of this guarantee agreement? and that is a performance, related to this by a party within the DIFC that would lead to discharge your obligation, maybe in the future. It's just hypothetical question.
Well, practically, maybe, but I don't think it's under the terms of the guarantee. The way the guarantee is drafted is that the obligation of the guarantor is an obligation independent of the obligation under the facility.
Well, I don't know. I think when you try to answer my question, I remind you not to look to the guarantee itself, but you can look at the whole surrounding circumstances. There can be an implied terms and conditions to this agreement as well. Many things involved. So what you just said practically can be, and then according to the contract cannot, according to the written contract cannot. So does that mean if the court can find any implied condition, and then the answer is yes, then all of your argument fall apart? I think you need to be very careful in addressing this matter or in answering my question.
Yes, Your Honor.
You got my point? So the question again, what if Totora did very well, the business went very successful, the Totora paid off the whole debts, automatically your client is discharged from the guarantee agreement? Is that a performance in your favor? No. Can be yes or no. I just need your opinion on this.
Well, Ms. Al Khalifa will have to pursue a claim against the restaurant. If Ms. Al Khalifa
paid the money to the bank according to this agreement, the guarantee agreement,
yes.
they will seek indemnity. How are you saying?
Yes.
Okay. Well, okay. Well, go ahead. Go ahead.
Yeah. So I was saying that the guarantee contemplates, pursuant to the terms of the guarantee, a payment by Ms. Al Khalifa to the claimant, and the claimant has not proved that it is established or licensed to carry business in the DIFC. And therefore it follows that a potential payment by Ms. Al Khalifa to the bank would take place outside of the DIFC. This payment forms the essential subject matter of the guarantee, and therefore clearly the guarantee was not performed or supposed to be performed within the DIFC. Finally, claimant argues with respect to Gateway B in the alternative in its skeleton on tab 7, it can be found at tab 788, paragraph 2931, that Ms. Al Khalifa evidenced that she signed the guarantee outside of the DIFC is irrelevant because she affirmed in the guarantee that she was to be treated as having signed within the DIFC. Claimant's position is based on the language in the guarantee after paragraph 15, page 58, that this guarantee has been executed by the guarantor, the place and the date first above written. Claimant argues that this means that Ms. Al Khalifa agreed that she was to be treated as having signed the guarantee within the DIFC. We submit, Your Honor, that this argument also fails. First, Ms. Al Khalifa disagrees with claimant's interpretation of this clause and submits that the heading of the guarantee containing the date and the first mention of a place identifies the main branch of the Commercial Bank of Dubai, where it says right at the beginning, date 6/04/2016 to Commercial Bank of Dubai, branch Main. Although at the IFC address is included in the guarantee, this simply forms a part of the definition of a customer as relating to the separate facility agreement between the claimant and the first defendant. Second, Ms. Al-Khalifa submits that the meaning of this provision is irrelevant and do not support the claimant's argument because even assuming that the provision created some sort of a contractual fiction that the guarantee was signed in the DIFC, which Ms. Al-Khalifa denies, the claim does not fall within one of the 5 gateways of Article 5A1. We submitted that the gateways involve an examination of factual circumstances. Either a claim falls within one of the gateways or it does not. The parties, we submit, cannot create contractual fictions whereby the claims which would otherwise not fall in one of the gateways is determined to, by virtue of the parties' agreement, to fall within Article 5A1. The judicial authority law allows for parties to essentially operate such a fiction under Article 5A2 by agreeing to opt in into the jurisdiction of the DIFC courts. However, even under Article 5A2, there are certain requirements in order for an opt-in to be valid, and we submit that this is not the case here. Article 5A1C also does not apply. Under Article 5A, the court of first instance shall have jurisdiction to hear and determine civil or commercial claims and action arising out of or relating to any incident or transaction which has been wholly or partly performed within the DIFC and is related to the DIFC activities. The claimant mentions Article 5A1C as giving rise to jurisdiction in its skeleton argument, tab 7, page 8, paragraph 28. The claimant states that Gateway C is engaged if the court chooses to examine the drawdown and expenditures of the loans as opposed to the contract per se. However, the claimant's argument, we submit, also fails with respect to Gateway C. Gateway C requires that the claimant to establish that the claim is one arising out of or relating to any incident or transaction which has been wholly or partly performed within the DIFC and is related to the DIFC activities. The phrase incident has been interpreted by this court as relating to a claim in tort. This is not the case here, so this can be disposed of quickly. With respect to the...
So you're saying the relevancy between the two contracts cannot be employed under this part of the law? You're saying the relevance between the two contracts,
Yes.
between the facility agreement, between the guarantee agreement,
Yes.
cannot be said to be related to a transaction that's
Correct.
excluded within the DIFC.
Yes, because our
It has to be tortious claim only, not contractual claim.
No, we're saying that the incident doesn't apply here. We're not referring to a tort. Claimant is not referring to a tort. They are referring to a transaction to the extent the guarantee relates to the facility. And our position is the facility and the guarantee are two separate contracts, and Ms. Al-Khalifa is not a party to the facility. The claimant argues, in fact, in paragraph...
Are you referring
27
to Justice Coleman judgment, is that right? What are you reading? Which part of your submission you're reading? No? What paragraph you're reading of your skeleton argument?
I'm referring to...
No, what part of your skeleton argument reading now?
I'm not reading my skeleton argument. This is my...
Oh, you're
outline.
not, okay.
But I'm
And what-
referring to...
Can you tell me what the relevant part in your skeleton argument?
I'm referring to paragraph 28 of the skeleton argument.
Yes, I see that. Yeah, go on, please.
Thank you. So, with respect to the transaction within Gateway C, the claimant argues at paragraph 27E of its skeleton that the performance of the facility, and thus the guarantee, was to be within the DIFC, and in paragraph 28 that Gateway C is engaged if the court chooses to examine the drawdown and expenditure of the loan of funds from the claimant to the first defendant. This is clear that the claimant's argument, therefore, under Gateway C is again based on a purported link between Ms. Al-Khalifa and the facility. The claimant focuses entirely on the transaction between the claimant and the first defendant, which involved a transfer of funds to the first defendant, who was a DIFC entity. Again, we reiterate that Ms. Al-Khalifa is not a party to the facility and has no obligation under the facility and cannot be said to be part of that transaction between the bank and the first defendant. Rather, any transaction between Ms. Al-Khalifa and the claimant was not supposed to be performed within the DIFC. In fact, Ms. Al-Khalifa gave evidence that only interacted with the claimant outside of the DIFC, and therefore any transaction could not be considered related to any DIFC activities. We conclude, therefore, that Gateway C of the judicial authority law also does not secure the jurisdiction of the DIFC courts on the claimant's claim against Ms. Al-Khalifa. Finally, Article 5A2 of the judicial authority law contains the so-called opt-in provision. Claimants specifically refer to Article 5A2 as an alternative basis for jurisdiction in the amended witness statement of Ms. Copley, and that's at tab 5, page 86, paragraph 26. Claimant also specifically addressed the opt-in provision in its skeleton argument. Pursuant to Article 5A2, the parties may opt-in into the jurisdiction of the DIFC courts in writing, provided that such agreement is made pursuant to specific, clear, and express provisions. Ms. Al-Khalifa submits that the parties did not opt-in into the jurisdiction of the DIFC under Article 5A2. Under Clause 15 of the guarantees, and that can be found at tab 2, page 58, this guarantee shall be governed by and construed in accordance with the law of the United Arab Emirates. Any dispute connected with this guarantee shall be submitted to the exclusive jurisdiction of the United Arab Emirates courts, and that shall not be construed as to limit the right of the claimant only to take proceedings in any other one or more jurisdiction. In Eddie S.A. France Ecobank Nigeria versus Laul Malhal, the MCC, 2016, DIFC CFI-024, that can be found in the Bundle of Authorities, Part 1, Tab 4, page 30. A jurisdictional clause that also provided a claimant with the liberty to pursue claims against a defendant in any court was found not to be valid opt-in under Clause 5A2, where the clause was not specific, clear, and express as to its intent to subject the parties to the jurisdiction of the DIFC courts. Ms. Al-Khalifa does not dispute that the DIFC courts are included as part of the Court of the United Arab Emirates. However, we submit that this is not sufficient to establish clause, not sufficient to establish jurisdiction, under Article 5A2. An opt-in clause must be specific, clear, as to the intention of the parties to have the disputes heard in the DIFC court specifically. The ability of the claimant to pursue claims in any other jurisdiction, as per the clause in the guarantee, we submit is irrelevant to the issue of whether the parties have opted into the jurisdiction of the DIFC courts. In Harold versus Haba, 2017, the IFC Small Claims Tribunal 127 can be found at tab 5, page 34 of the Bundle of Authorities. Judge Mahal Mihari examined a jurisdictional clause very similar to clause 15 of the guarantee and granted the defendant's application to contest jurisdiction, as there was no indication that the parties opted into the jurisdiction of the DIFC courts, where the agreement as executed between the claimant and the defendant is an agreement that has a general jurisdiction clause and does not name the DIFC courts. Judge Al-Mihari also found it relevant that the agreement in reaching her conclusion between the parties was a form agreement issued by the claimant. Similarly, here, the guarantee contains only a general jurisdiction clause and does not name the DIFC courts or the DIFC law. Moreover, the guarantees entered into by Ms. Al-Khalifa's co-defendants in this claim are identical to hers, and therefore we can conclude that the guarantee is a form agreement issued by the claimant. We submit that this demonstrates that clause 15 of the guarantee is not made pursuant to a specific, clear, and express provision such that the parties opted into the jurisdiction of the DIFC courts. Instead, in interpreting whether an agreement is made pursuant to specific, clear, and express provision, it's necessary to look at the overall circumstances and ascertain what the parties really intended. In the present case, clause 15 of the guarantee does not prima facie accord jurisdiction to the DIFC courts, because the phrase United Arab Emirates Court could refer either to the DIFC courts or the non-DIFC Dubai courts, which are also located in the territory of the United Arab Emirates. Therefore, the court is tasked with construing clause 15 in the context of the guarantee in order to ascertain the meaning of the clause and the objective intent of the parties to the guarantee. Here we submit that the services under the guarantee, which was the payment of a sum by Ms. Al-Khalifa directly to the claimant and non-DIFC entity, was not performed or not supposed to be performed within the DIFC. The guarantee is in Arabic and English, and clause 15 of the guarantees also dictates that in the event of any difference of interpretation arising between the text, English or Arabic, the Arabic text shall prevail. This would prove to be difficult in the DIFC courts, where of course the Arabic language is not used and the parties would have to recourse to the aid of expert translators.
Well, I don't understand how this argument supports your case. I mean,
this supports my case.
We received cases from many different jurisdictions. Can be Chinese, can be Brazilian, Portuguese, Spanish. They refer to this court. Then we have testimonies or statements in different languages. So we translate everything. We deal with everything. I didn't think. I don't know why the technical. See, this can be raised. This kind of difference can be raised in case of forum, maybe an inconvenience, when we have like the jurisdiction is available for two different jurisdictions, and then the court is to find which one of the two given jurisdiction is a more suitable to hear and determine the case, but not for just the mere defense of one of jurisdiction. I really don't see what kind of link you're making because of the language. I mean, You got my point.
Yes, Your Honor.
Yeah.
It's not only because of the language, and we are aware that the DRC courts have received courts from different jurisdictions with pleadings or parties originally for different countries. But what we're saying is that in order for the opt-in provision to kick in, the agreement must be specific and clear. And the DIFC courts have provided guidance on how to interpret whether an agreement was clear enough for the parties to opt in into the jurisdiction. I'm referring to the different factors in Santec, where the Justice Santec versus Altamini Grand Valley, 2017 DIFC CFI-047-2017, where Justice Sir Jeremy Cook clarified the meaning of the requirement that the agreement to obtain must be specific, clear, and express, and said that the court must construe the contract in issue to determine the party's chosen jurisdiction when faced with clauses that do not prima facie accord the jurisdiction.
Yes,
to the
I do
DIFC
understand
courts.
this. I do understand what it means specific and clear, but I think, well, my problem is that I said, what's the language to do with this? I mean,
The language is just one of the factors that the court can consider in order to determine what was the real intention of the parties. For example, in Santec, I believe that Justice Cook looked at the fact that the agreement was in English, that at issue was a trust that was an institute only present in common law countries. So we're not looking at only the language per se. We're saying that the language is one of the factors that in the overall circumstances the court has to consider. And here the overall circumstances are that the parties are not DIFC entities, that the agreement was not supposed to be performed in the DIFC, that the agreement is not only in English, that Ms. Al Khalifa didn't have any contact with the DIFC, that the agreement, that the guarantee was not signed in the DIFC, and that Ms. Al Khalifa evidence is that she did not intend. Where is the witness statement of Ms. Al Khalifa?
she signed outside the jurisdiction.
Yeah, that she signed outside of the jurisdiction, and she said, paragraph 5, it was my belief at the time of signing that if the claimant and myself had a dispute connected to the guarantee agreement, that claim would be brought before the local courts of Dubai and not in the DIFC courts. So what we're saying is that we're not focusing only on the language of the guarantee and the fact that the Arabic language is present in the guarantee, but we're saying that in the overall circumstances of this case, and the fact that that the agreement pursuant to which the opt-in should kick in was not sufficiently clear and specific to grant jurisdiction under Article 582. Yes, so accordingly, we respectfully request the court to grant Ms. Al Khalifa's application and dismiss the claims against Ms. Al Khalifa on the grounds that the DIFC courts lack jurisdiction. We also submit that the claimants should bear the cost incurred by Ms. Al Khalifa in relation to Ms. Al Khalifa application. I don't have any other submission unless Your Honor.
Well, I thank you very much for your submission. I just want you, before I turn to the fourth defendant or the claimant, I would like you to take me to the Justice Coleman judgment that's mentioned in 28, in paragraph 28 of your skeleton argument. I think it's behind tab 3, page 19. I did not have the chance to go through this. I just need to visit this before I turn to the other parties.
If it will assist you, Honour, it's in the authorities bundle, tab 3.
Yeah, right. And what is the relevant page on paragraph?
Page 19 on the bold lettering at the bottom of the page. You'll see the paragraph 19.
Is this part of your submission?
No, it's...
Would you be addressing me in this later on?
Your Honour,
But I can look at it.
Yes, and my point in relation to the quotation made or relied upon by the applicant here is simply that there was the old law. Before the amendment in 2011, it was simply whether or not there had been an incident. The additional words that are contained in 582 is all transaction.
Transaction was not there.
Exactly, and so the reference at all actually in the context of the old law.
Yeah, but see, I still need to. Yeah. What paragraph, Serena?
Paragraph 18.
18. Okay. So
19, sorry.
19.
But what is citing? It's only to say that it's... But Your Honor, I apologize. Our paragraph 28 of the skeleton, we cite this case only just to say that in this case it was not a tort under 4. We were not going to deal with the tort issue.
Yeah, I see. I just need to see the interpretation of incident. Well, thank you very much, sir.
Thank you.
I might come back to you later on.
Yes.
Well, if I may ask the claimant first, if they, what would you prefer, whether to reply to the Mr. Khalifa submission, or you just need to wait to hear from the fourth defendant and then give one defense to all of them? Or is this your preferred order?
Yes, to my mind it makes more sense if Mr. Hartridge adds whatever he wants to say, if
Yes.
decisions will be made, and then I'll deal with everything in one go.
Oh, I see. So the jurisdictional, the contest of jurisdiction is based on a similar argument?
As far as I can tell, they are identical.
Oh, I see.
Marginally different wording in the application notice and the witness statements, but I think substantial arguments.
Agree, okay. We'll hear from Mr. Rafai now.
Your Honour, I appear on behalf of the fourth defendant. I will take the numbering we agreed earlier.
You are the fourth now.
Yes. My colleague accepts, I'll refer to her client as the third defendant.
If you're happy with this number, the court, never mind.
So the third and fourth defendants are jointly and severally liable under their respective guarantees, which contain identical terms and were executed in identical circumstances. As such, the fourth defendant shares substantially the same position as the third defendant in respect of arguments submitted to the court in support of the application for dismissal of claims against the guarantors for want of jurisdiction. And as a result, it's not my intention to run through the same arguments and discussion which have been so ably presented by counsel to the third defendant. And suffice it to say at this point that the fourth defendant agrees with such arguments and adopts them mutatis mutandis as his own submissions to the court. I will therefore limit myself to certain additional remarks, which I trust Your Honour will find of assistance, and perhaps also will go some way to answering questions raised by Your Honour earlier. The starting point is clause 15 of the guarantee, and the court will certainly have noticed the inherent contradiction in its wording. Exclusive jurisdiction is what is agreed, but then there is a carve-out which says that this exclusive jurisdiction shall not be construed as to limit the right of the bank only to take proceedings against the guarantor in any one or other jurisdiction. Now,
So you're saying, although it's like labeled as exclusive, it's not an exclusive term.
no, I'm saying there's an inherent contradiction.
Yeah.
Either it's exclusive or it's not. And to the extent that the carve-out in the third sentence purports to limit that jurisdiction, in my view, this must be interpreted in application of the contra proferentum rule, as this is a standard form guarantee which is being presented by the bank and should be interpreted against the interests of the claimant, and as such they cannot rely on that purported right on the sole basis of the interpretation of the clause. If I may venture to suggest that the resolution of the contradiction, even though this is not an issue before the court, it seems to me that the logical explanation would be that the carve-out was intended only to refer to ex parte proceedings which the bank may take in other jurisdictions seeking injunctive or other conservatory measures, and this is supported by the word only, whereby in ex parte proceedings the claimant would be the only party taking those proceedings. But that is an aside, it's not the issue before the court. Turning now, I'll just home in on certain key aspects. Turning now to the witness statement of Ms. Copley in paragraph 25C, she somewhat disingenuously states that the claimant, by virtue of this clause 15, can commence proceedings in any jurisdiction it sees fit. This is clearly wrong. A court in another jurisdiction would not consider itself to be bound by the purported jurisdictional carte blanche that the claimant has granted to itself in clause 15, but that court would need to satisfy itself that it was competent to hear the case in accordance with its own rules and or those of private international law. And such an exercise of determining competence is precisely what is before the court today, and cannot be circumvented by the last sentence of clause 15. Further, in respect of Ms. Copley's witness statement in paragraph 25D, she makes the somewhat extraordinary statement that the first two sentences of clause 15 of the guarantee are irrelevant. Well, the clause 15 is the jurisdiction clause. The first two sentences actually form the substance of that clause and deal with the very issue which is before the court today, the question of jurisdiction. Therefore, they cannot be written off as irrelevant. The first sentence states that the governing law is UAE law, and the second that UAE courts have exclusive jurisdiction, paraphrasing. The clear primary meaning of these two sentences when combined is that the agreement envisages that UAE law be interpreted and applied by UAE domestic or onshore courts. And this is the clear understanding of the fourth defendant as he sets out in his witness statement at paragraph 5, in which he states that it was his belief that the onshore UAE courts would have jurisdiction and that there had been no discussion of DIFC courts possibly determining any dispute. And I note that his position is shared by the third defendant in her witness statement. Now, this is supported by the fact that the guarantees are in Arabic. I listened carefully to Your Honour's question earlier.
Yes.
So this understanding of the fourth defendant is supported by the fact that the guarantees are in Arabic as well as English, with Arabic prevailing in the event of conflict. It is also clear that the claimant itself intended that the guarantees be subject to the jurisdiction of the UAE courts from its use of its standard form guarantee, which the claimant uses for all its onshore banking financing, and the fact that when the first demand letter was sent by the bank, it was sent in Arabic. So up to that point, the sending of the first demand letter, it's quite clear to me that all the parties thought that they were en route for the UAE domestic courts. What
So you're
appears
saying the interpretation, I mean, taking into account all the surrounding circumstances, shall lead to the interpretation that parties intended that UAE domestic Arabic court is the court to be involved, applying local laws, which, I mean, opposed to the DIFC laws and DIFC jurisdiction, and that's what you said.
This is what I'm saying. I'm obviously interpreting from the circumstances and the documents what the claimant intended, but it seems to me that that would be entirely consistent with the way that the matter was concluded and subsequently conducted by the claimant.
And the last sentence in that, in clause 15, is irrelevant because the claimant cannot decide solely the jurisdiction of either domestic court or even this court. That's what you're trying to say.
Absolutely. It's in clear contradiction with the preceding wording, which Ms. Coakley tried her best to discard as irrelevant, but exclusive jurisdiction of the UAE courts clearly overrides a contradictory statement about a right to choose jurisdiction as the claimant sees fit.
And then the jurisdiction of UAE court would be found under the maybe Civil Procedures Code that determine which court should deal with the matter. Not even the choice of the claimant, and that's what you're trying to say.
Right. I'm addressing the intention of the parties as they are at the moment. And that is then linked into the case which my learned colleague for the third defendant presented in the court, whereby where there is no clear, precise attribution of jurisdiction to the DIFC courts, but a general jurisdiction clause, then the court is invited to consider all the circumstances, including the language, including the intention of parties and so on.
I see your point, yes.
Thank you. So as I say, in my view, it's clear that the parties, including the claimant, up to the point of the issue of the first demand letter in Arabic by the claimant, were all intending that the dispute would go, if it went further, to the onshore courts. And it appears that claimant's counsel, not themselves licensed to appear before the Dubai courts, for some reason persuaded the claimant to seek recourse under the guarantees through the DIFC courts. That is inconsistent in our view with the documentation and the circumstances in which the guarantees were executed. The reference here is to the Suntec Lifestyles case, which counsel to the third defendant submitted to the court, where a jurisdiction clause does not prima facie accord jurisdiction to the DIFC courts, which is the case here, invites the court to consider all the circumstances, parties' intention, whether the contract was to be performed in the DIFC, whether by a DIFC entity, and the language of the contract. These arguments of the fourth defendant and of the third cannot be swept aside as counsel to the claimant tries to do in his skeleton argument of paragraph 22 by simply labelling them as misguided. They are very much on the point and should be taken into account by the court. I would add also that the claimant's counsel is in error when he states in paragraph 20 of his skeleton argument that the fourth defendant makes no positive assertion that he executed the guarantee outside the DIFC. A positive statement to that effect is included in his written statement in paragraph 4. The import of this statement is in no way invalidated by the claimant asserting by reference to the guarantee and its execution in the place first above written, as ably argued by counsel to the third defendant. The geography, if you may say, of the guarantee is such that the first place to be mentioned is the main office of the bank, and the only reference to the DIFC above the signing block is the reference to the address of the customer. And therefore the claimant's argument based on J.P. Morgan and Springwell is itself misconceived, and the assertion that the guarantees were supposed to be concluded and or finalized in the DIFC, arguing from that point, is therefore unfounded. I would like now to turn to the issue of the phrase arising out of or in relation to, as it appears in Article 5A, 1B and C of the Judicial Authority Law.
Yes.
Counsel to the claimant refers to case law in which these or similar phrases are considered as they are used in the interpretation of insurance policies, whether in respect of an aggregation clause for the purposes of determining whether a deductible has been exceeded, or whether in respect of the applicability of an exclusion clause. It is well known the case law on interpretation of insurance policies is specific to such type of contract and should only be applied sparingly to other types of commercial contracts. Having made that general point.
Were you saying you want to distinguish this precedent because it's dealing with a very specific law, which is insurance law?
It's dealing with very specific clause in a specific type of contract, either an exclusion clause or an aggregation clause, aggregation of claims clause, on which there is a whole body of specific case law which leads up to these cases. And although they may be informative, they are not, in my view, sufficient on which to base an interpretation of Article 5A 1B when it comes to arising out of and in relation to.
Right.
It's a caveat, if you like, Your Honour. Going further, then, having said that, arising out of or in relation to clearly means something more. It clearly means a more remote connection with the contract than the words such as under or pursuant to would mean. But a causal connection there must be, and in this case, the claim under the guarantee cannot be characterized as a claim arising out of or in relation to a contract concluded, finalized, or performed within the DIFC, pursuant to express or implied terms stipulated in the contract, which is the wording of Article 5AB(1).
Yes.
We've already heard arguments to the effect, which we concur that the guarantee was not concluded or finalized, or indeed the guarantee was not performed and is not to be performed in the DIFC. The argument of the claimant that the contract referred to in this article, Article 5AB(1), can be interpreted to refer to a sort of combination of both the guarantee and the credit facilities agreement, a sort of conflation of two documents, on the basis that these two documents are effectively one and the same document, is both factually and legally untenable. In line with standard banking practice, the claimant's standard form of guarantee, which is reproduced in the guarantees before the court, seeks to dissociate the guarantor's obligations from those of their customer in order to create a primary debt owed by the guarantors, enforceable independently from the debt owed by their customer. This is the banking world's dream situation. This is their best shot at making sure that guarantors can be dealt with without reference to the underlying customer indebtedness. And this is demonstrated by the following provisions of the guarantees, some of which we've looked at. In Clause 2 of the guarantee, the payment demand has to be met under any circumstances and for any reason. Now, this is extremely wide wording, and on the face of it means that the guarantee could be called for a reason unconnected.
I mean, And the same argument you're raising, what you're saying, the bank wishes, or the bank's dream, like to make this kind of separation to agreement, but that means they suppose not. It's supposed to be one. That's what you're trying to argue. Another word, maybe. Am I right?
It's supposed to be one in what sense?
Well, you started your argument by saying the bank or the banks. You said you used the word banks.
Yeah.
Now, through this kind of guarantee agreement, try to create a new document where they can pursue whatever claim or obligation against the guarantor in complete independent way from the original facilities.
Right.
Well, you call this is dream, or this is what the bank wishes to do.
Yes, it's
Does that mean in
my-
reality they're supposed not to do this? They're supposed to treat both without, like, and as in this case, like the facility and the guarantee as one transaction? And so the dream should not extend to make a full separation between the two documents. You go my point.
What I'm saying is I think that this, maybe dream is unhelpful, but I'm saying actually they've realized their dream in this document because the way it is worded is such that they have the right to call on the guarantee irrespective of what is happening with the underlying indebtedness.
Yes. And that's what I meant by they would to make a full separation between
Right.
the two. Yeah.
Right.
But you call this it's a dream of
Well,
the banks.
This is what
And
the banks
someone would
always
say
intend.
then the case should be vice versa. Is that right? Maybe not.
Dream is perhaps unhelpful, but banks banks want to. When I act for guarantors, Your Honor, I always strike out this wording or make sure that the guarantee is umbilically linked to the facilities agreement, and that is the process of negotiation of guarantee. This is a standard form guarantee which puts the best case for the bank, which is the bank can ignore effectively on the face of the wording its dealings with the customer and call the guarantee for any reason and at any time, and it has to be paid on first demand. The other
Well, but didn't you agree with me that like these two, like whether the facility agreement and the guarantee agreement are very linked and connected by way or another, because default and payment in one of them would raise liability in the other one. So the connection is there, maybe the base is there, the cause of action. Don't you see that?
I'm making a distinction here. We're not before the court today to discuss enforcement of the guarantee and the conditions of enforcement. We're here to discuss jurisdiction.
Right.
So I'm not addressing the commercial realities represented by, on one hand, the credit facilities agreement, and on the other hand, the guarantee.
But we're still discussing connection between two, what you would like to call two different transactions.
Yeah. What I'm seeking to say is that the causal connection which the claimant is trying to establish between the guarantee and the facilities agreement, in order to squeeze both of them into the definition of Article 5A B1 when it refers to a contract.
Right.
They're trying to squeeze both those documents into a definition which refers to one contract. And I'm saying that on the face of it and on the wording of the guarantee is not possible.
I say that the intention of the bank to make a full separation. That's
Yes,
why
exactly.
the guarantee
Exactly.
agreement drafted in this way.
Because
Well,
commercially it's in the interest of the bank
I
to
see.
be able to go after the guarantors without having to justify, without having to prove their records of the indebtedness to the from their customer is final and binding. They say, we're owed this amount of money, you've got to pay first demand, and they don't have to give any reason or provide any proof to justify that. So that commercially for a bank, that is what they're seeking to do in this document here, and that is why, in my view, it's shared by the third defendant, to conflate two legally binding, detailed documents, which are the facilities agreement and the guarantee, to squeeze them into the definition of a contract, which is required by section 5A(b)(1), sorry, 5A(1)(b), is legally untenable.
I see about this.
Yeah. So it's really the wording of the contract, and here we're not talking about the commercial effect of the contract. We're talking about what the contract, what the guarantee says about itself, and whether that creates a parasitic relationship, to use counsel to the claimant's description, with the facilities agreement, or whether they are two distinct documents which cannot be squeezed into the definition of a contract. So clause 2, demand has been made under any circumstances for any reason. The payment has been made on first demand without having the right to request the legal recourse to be first initiated with the customer. In clause 6, the claimant has the right to deal with its customer in any manner without such dealing affecting its rights under the guarantee, even to the extent of increasing, varying, renewing, releasing the customer's indebtedness. So there's a complete separation.
What is clause 3? Is it you're reading clause 3 of the?
Sorry, that was clause 6.
6.
I paraphrased it, but I can read it if you like.
No, I got your point. I just need to make a record of what you said.
So the bank's giving itself a completely free hand as to how it conducts its relationship with the guarantor, irrespective of the actual state of play with the debtor, with their customer. And as I say, their records are of the indebtedness are completely binding. This is clause 9 on the guarantor. And the guarantor has no right to challenge such records and has to accept the bank's word for it as to how much they're owed. So the inclusion of this type of wording is in order to establish a relationship under the guarantees that is exclusively between the claimant and the guarantors, exclusive in the sense of excluding the facilities agreement in all respects other than providing consideration for the guarantee. So this is the basis for our argument. For the purposes of whether the guarantees fall within the definition of Article 5A(b)(1, the guarantees must be considered to be autonomous, standalone, legally binding documents for which the facilities provide consideration and nothing more. So the causal connection, which may on the face of it arise out of the wording arising out of or in relation to, i.e. slightly more remote than pursuant to or under, has been broken by the fact that there has been interposed between the claim being made and the contract referred to in Article 5A(b)(1) as being to be performed in the DIFC. That causal connection is broken by the interposition of the guarantee, which is an independently enforceable document. And the causal connection cannot be carried through the guarantees to the facilities agreement in a sort of the seamless way that the claimant requires in order to qualify both as a contract which is concluded and performed within the DIFC. And finally, I would just like to re-emphasize that Article 5AB2 is also inapplicable because it requires a written agreement containing specific, clear and express provisions relating to the filing of claims or actions in the IFC courts, and by no stretch of the imagination can be considered that Clause 15 complies with this description. I think I would like to draw to a close there unless anyone has any further.
No, I think you have covered all of your submission and all of my question maybe to that. D4. I may come back to you after hearing from the claimant.
Thank you very much.
Thank you very much.
Your Honour, but before I start, I should just check. I was told to call the hearing started, but apparently our listing has been reduced to only 2 hours today. I don't know whether that's Your Honour's understanding as well, but I'm conscious it's now almost 11:30.
Well, I think 2 hours is sufficient, maybe. Well, if there is a need, I mean, to extend for a shorter time, short time, well, we might do that if there is a need for it. Otherwise, I would invite you to finish it on time.
Yes, I'm very well. I'll try and speak to I'll try and be done at least 5 minutes.
As we can see, when I have your submission anyway, I have all parties' submission and I have your authorities and everything.
So, Your Honour, in my respect for submission, this application or these applications raise basically 3 broad principles for determination by the court. The first is the scope of Article 5A1B.
Right.
Secondly, the proper interpretation of the contract and whether or not that engages the opt-in clause in 5A2. And thirdly, and connected both to issues 1 and 2, is whether or not the contractual estoppel argument allows me, even if I fail the above arguments, to mean that we succeed either in establishing 5A1B or in 5A2. Where I'll start, if I may, is by addressing the elephant in the room in some circumstances. It's the facility itself, and that, of course, is studiously ignored by the applicants who seek to persuade the court that the 2 buildings are entirely unrelated and independent. The facility agreement between my client and Totora clearly engages Article 5A1A. Totora is a DIFC establishment. I note and understand and respect the applicant saying they're not making any submissions on behalf of Totora, and they shouldn't be deemed to accept my points in relation to that. But I would say that it couldn't be seriously arguable other than that 5A1A is properly engaged for Totora. It was a restaurant located at the IFC, and the company itself was registered here. And Your Honour will have the page citation in my skeleton argument. I can give it to you again if it insists. Just setting out the relevant printout from the IFC company's register.
I've seen that.
So, in the facility itself...
But you assume Totora and the other party in different cause of actions, is that right?
Yes. Right. Yeah. So I fully accept that we are pursuing the defendants under 2 different contracts. What I am saying, though, is that they are related to each other. And all I need to establish in order for this court to be seized of the claim against all 4 defendants is to show a relationship of the requisite standard between the facility and the guarantees. If we look briefly at the facility itself, and the jurisdiction clause there. This is in tab 2. I'm looking here at Ms. Al-Khalifa's bundle. Tab 2, page 40.
Is it 40?
Yes.
Right. Close.
Clause 19.1.2.
Yes. Do and raise issues.
Yes. So if I could ask Ron just to read that briefly to yourself, and I'll make a couple of quick submissions in relation to it.
Yeah, I read this before and I heard it 3 times today. I'm okay with that. You may go on.
You want to, the second point I make in relation to that clause, we have the reference to courts of the United Arab Emirates, and it is surely beyond argument now, or beyond serious argument in this court, that this court is a court of the UAE. That's been established numerous times, and the relevant case in the bundle, if you're on, is the IGPL and Standard Chartered case. Where
And none of the party has said otherwise.
Yes, though there has been
They never said the IFC is not a UAE court. They said it's different, its jurisdiction need to be found in a specific way.
Yes, well, so what I understand the applicant is saying is that once you look at the contract as a whole, the guarantees as a whole, the DIFC court hasn't been included within the list of courts that could be seized of the claim. My point in relation to the jurisdiction clause in the facility is that the jurisdiction clause in the facility is similarly, but slightly different worded, to the jurisdiction clause in the guarantee. That clause 1A is clearly engaged, and there is clearly no opt-out in the jurisdiction language within the facility itself. So my starting point is that we are in the right and the only court to bring proceedings against Totora. And the context of our claim against the other defendants is very important to set, but we have no other option but to be here against Totora. And that then drives the claims against the guarantors. So if one then turns on to the...
So you're saying with Totora you have no other option but the DIFC court?
Yes. We are, under Article 5A1A, the DIFC has exclusive jurisdiction, and therefore we have submitted to it in bringing the claim for the DIFC. Now, if we were to pursue the guarantors separately on the onshore court, we would then have a multiplicity of actions. We would also have a situation where potentially have conflicting judgments if, because inevitably, whichever court looks at this at trial will be looking at the terms of the facility itself, as well as the terms of the guarantee, and will be seeking to make findings as to the proper interpretation of those clauses. And obviously, if you have two different...
Yeah, but this is not a very unique situation because, I mean, if you look worldwide, you might see like action facilities like, for example, in America, guarantee in England, and that would work. Conflicting judgment is something possible, and then you can deal with it according to the international private law. I mean, this is, something expected.
Well,
it's nothing unique. You're not talking about a new case.
I'm certainly not saying anything in this case is unique or novel, nor am I saying anything particularly difficult. What I am saying is that we are in the correct court in pursuing all four defendants in this court.
Okay, I will see. I will see. By the end of the trial.
Yes, I certainly said it's your honour to.
You got to convince.
Precisely.
You have to
make
convince.
the finding, but that is the core of my submission.
Yes.
So we have then the language of the jurisdiction for the facility itself. Turning then to Article 5A1B.
No, we have the language. My understanding, what you're trying to say.
Yes.
You have given reference to UAE court. DFC is still UAE court. We cannot depart from this interpretation to this limit and full stop.
Yes, and the only conclusion I ask you to draw from clause 19 is that there has been no opt-out from the DIFC.
From UAE or from DFC?
From the DIFC.
Not from UAE.
And it follows nor from the UAE. That under Article in facility.
Well, one of the party might say the last sentence of that clause 15 is opt out from everything. Then you give yourself the chance to go where else, and then you kept no exclusive jurisdiction to any court. There is no definition to any valid jurisdiction link, because you choose to have the world open for you to sue the defendant. I haven't heard it in this way, but I said, hypothetically, one party might argue that.
Well,
the last sentence of clause 15.
Yes, Your Honour. So I'm talking about clause 19 of the facility. The language in clause 15. You're right, but the last sentence provides the my client with the option to bring proceedings in other courts without prejudice to the exclusive jurisdiction clause. The first sentence of clause 15. The wording of the clause, frankly, is not ideal, but this court does not operate in ideal events, and it falls simply for this court to interpret the proper meaning of both clause 19 and clause 15. In relation to clause 19 of the facility, I say simply that Article 5A1A is engaged, and there is no opt-out under Article 5A3 through clause 19. So I ask the court to draw the conclusion that this is the proper court to be seized of the action between the bank and Totora.
Right. According to the facility agreement.
Yes, according to it.
Right.
Moving then on to the guarantees. Clearly I don't rely on 5A1A for those. I principally rely on 5A1B. And my argument...
Maybe C.
And maybe C, but I don't particularly press that point beyond just making the basic point that 5A1C is wider. I've already made the point briefly in an argument for that, addressing that simplicity. But if we look briefly at the Khalil and Shura Capital case, this is in the authority, and we can dispose of the 1AC argument quickly. This is in the authorities bundle, is now Khalifa's authorities, tab 3. And paragraph 19 on page 19 of the bundle,
right.
And you'll see there that the commentary by the learned judge is that he's looking at the old law when 5A1B used to say an incident that has occurred in the centre, and that clearly envisages a particular event on a particular date in a physical location. There is no reference there to or transaction, and that was previously elsewhere in the jurisdictional clauses. So the next sentence, which is the one relied upon by the applicant, Khalifa, that reliance is misconceived, I say.
But would you give any weight to the statement, like the first quotation, like in paragraph 19? This takes one outside the scope of contract or transaction. Can we draw any inference that the judge, even in that time, wanted to say incident is not contract, incident is not a transaction?
Yes.
Even in that time, so this can be still valid.
Of course.
To draw a distinction between incident and contract and transaction.
If this court were embarking on a full interpretation of 5A1C, which I say is unnecessary for the purpose of this application, the court would clearly have regard to earlier findings in relation to the old wording of 5A1B and conclusions reached in that wording as to the word incident and what that means. Now, it's possible that the word incident takes on a slightly different meaning when seen in a different context. But my initial thought is that probably wouldn't be the case here. Simply that the overall scope of 5A1C, as it is now drafted, is wider than simply claims in tort or claims for breach of fiduciary duty or these sorts of issues that might arise purely out of an incident, and instead we will also look at transactions. So the overall purpose of 5A1C is to enable the court to look beyond the strict confines of contractual cause of action or cause of action as to whether or not there even is a contract between the parties, when determining whether or not it has jurisdiction. Now, in this case, I say that the cause of action is contractual, so the court can confine its matters to 5A1B. But to the extent the court...
And that's sufficient for you, yeah?
Yes, and that is sufficient for my purposes.
So you raise this only in the defense to the D4 submission?
Now, in relation to the language of 5A1B, we have reference there for claims arising from or relating to a contract, and then the word that forms words that follow after that. The contract being referred to, I say the court can make one of two findings. A contract, for the purpose of this case, can be either the guarantee or the facility. But on either basis, the claim is sufficiently related to those two documents, to each of those two documents, to mean that the court should exercise jurisdiction or must exercise jurisdiction to resolve the claim. In relation to the guarantee, with that, we look at the facility perhaps first and come to guarantee, because logically the two work in
I'll follow your order.
If we turn back to the guarantee, sorry, the facility itself, and I'll take you on quickly through a number of key terms. I'll start on the schedule at page 12 here, within tab 2.
Page 12, yes.
You'll see that inside the third box on that page, there's personal guarantees of the shareholders.
Right.
And we'll see in due course that there are numerous references going back to the individuals listed here, being the security providers in the facility language itself. So we have here this, the core wording that says that the each of those three individuals need to execute personal guarantees as a condition precedent, looking through to part 3 on the same page, for the facility to come into existence at all. So it follows from that if the guarantees haven't been signed, there will be no obligation on the bank to actually permit drawdown of the loan. Then turning through to the general terms and conditions of the credit facilities agreement, this starts at page 19 of the bundle. And the relevant definitions to look at are, if you turn through to page 22, you'll see just in the around the middle of the page, there's a defined term, guarantee facility.
Yes.
And turning over the page to page 23, you'll see the term obligor. And as I've just mentioned to your honour, the three obligors in this case are the second, third, and fourth defendants.
So where is that in the next page?
That's it. So page 23, it is approximately 1/3 down. For me, it is just below the top hole punch.
I see, yes.
It means the borrower and each security provider. the defined terms group provider is itself defined over at page 25. And that's broadly on the same part of the page, just below the top hole punch.
Security provider?
Yes, it means the security providers listed in the schedule. Starts off by taking you on to that schedule. And towards the top of that page, there's security documents referenced there to, again, the security documents listed in the schedule. Then turning through to the substantive clauses of the facility, clause 3.1 provides this is at page 26, provides the full wording as to what the conditions precedents actually are. And in basic terms, there must be compliance with the schedule as a condition precedent for the loan itself. And going down within 3.2, you have some express conditions precedent within the general terms and conditions, and subparagraph G is relevant here. Each notice to be delivered pursuant to a security document, i.e. guarantees and acknowledged thereof. Turning through then to page page 35, we have here events of default. And clause 12.1, subparagraph G, establishes a cross-default obligation and scenario, whereby if the guarantors don't pay money on demand, that in itself constitutes a breach of the terms of the facility.
The three defendants are not signatory to this document, right? On the Totora.
Correct. In terms of parties, yeah. The three defendants were signatories in their capacity as shareholders, but they're not parties to the facility.
Right.
Turning through to page 37. Clause 13.1. This is a contractual requirement here, which is not expressed as a condition precedent, requiring the provision of security in the form that's set out in the relevant schedule.
You said 13.1?
13.1.
Yeah.
And finally, with due deference to Your Honour's comments about the irrelevancy of language, given that the point about Arab language was taken against me, just to complete this, I'll take you to clause 16 of the facility, which says in relation to the facility notices need to be in English. Now, you all asked about the signatories and the actual signatures given at page 43 of the bundle. And those are the three signatures of the individuals. We then have the guarantees. These are identical, all are in the bundle. The one I've marked up was the guarantee executed by Mr. Ramadan That's at page 50. So we have here from the guarantee at the top of the page an express statement that the consideration for the guarantee itself is the bank entering into granting the loans. In clause 1, each of the guarantors accepted a joint and several obligation to repay indebtedness up to 4,500,000 dirham. And under clause 2,
so this with the reference to the facility, credit facility agreement, right?
Yes. So we have here references back to Totora in effect throughout this document. So we have in clause 1 an acceptance by the guarantors that the terms of the facility can be in effect transposed onto them, and that they will accept all obligations undertaken. So within clause 1, you can read the entirety of the facility. Within then clause 2, we have here the obligation to make payments, and these are payments on demand. Clause 3 deals with Your Honour's very pertinent question to both the applicants as to what is the consequence of Totora paying down debts. And the answer is very clearly stated in the guarantee itself, that for every dirham that Totora paid down the debt, that would be one less dirham owed by each of the guarantors. Then turning through to clause 7, towards the bottom of page 51, Your Honour will see a reference there to the Federal Civil Code and the disapplication of Article 1092. And under clause 14, the primacy of the Arabic language. And then clause 15, we have the jurisdiction clause. So you want to drill down a little bit further into the jurisdiction clause itself. The court doesn't need to make any findings at this stage as to which substantive law it will seek to apply going forwards in this case. The court will also be familiar with Article 6 of the judicial authority law, and just because one substantive law is used over another, that's no reason for the court to decline jurisdiction. The court is well familiar with the processes of doing so. But it may well be, that given the language of Clause 7, that the first sentence of paragraph 50 is interpreted as meaning that the civil code is applied in this case going forwards.
Can this court apply the civil code, even if party agreed to do so?
Your Honour, yes.
I would draw your attention to the exemption from application of the civil laws before this court.
Your Honour, it's
law number 8. This court is exempted from the application. The court, the parties, and everyone in the DFC are refrained from applying the civil code.
Well, Your Honour,
right? Or you would refer me to the party's choice.
Your Honour, yes. My point is that no findings can be taken in relation to this point at this stage. We're simply looking at whether the court is seized of the action that will be sort of undertaken to look forward. The point is taken against me that any reference to the civil code is fatal for my jurisdiction argument.
Even the language.
Pardon me?
Even the language of the contract itself. And what they try to do, to say,
Yes.
the application of civil laws or even the language of the contract, as what they're trying to say, is it's much helpful factors to their own contest of jurisdiction.
Well, that's correct. The court is taken to the primacy of the Arabic language over English language, and the court's response to that is quite rightly, well, so what?
But I didn't respond, I just was arguing. I wasn't a response to their argument, it was just...
Yes,
it's a mere discussion.
I'm in no way suggesting that you expressing settled views, but your question posed to some other friends had no proper answer. For the simple reason that there can be no proper answer. The adoption or primacy of one language over another in a contract is not a matter that should ought to trouble this court. It can simply be dealt with through translations. So we have then the.
So what you have taken me through now, what are you saying? This is what established and found the connection between the two contracts.
Exactly that, right. My point is that the claim against the individual guarantors arises from the facility. It relates to the facility. Alternatively, it arises from the guarantee or relates to the guarantee. And within the guarantee itself, by clause 1 of the guarantee, the court reads in the entirety of the facility. I will, as I may, adopt Mr. Hartridge's comment about the umbilical link between the two documents, and that's exactly what they are here.
Is this true, despite the fact that we can see Article 5 of the Guarantee Agreement says you'll be liable to pay this debt according to the Guarantee Agreement, and relevant to the Facilities Agreement, what's happening there. This is what's written in Article 5 of this agreement.
Well, so
as D4 tried to say, Article 5 is, a precise disconnection between the Facility Agreement and the Guarantee Agreement.
In my spoken submission, it's exactly the opposite of that.
Mm-hmm.
That what we have here is a statement that events of default are not required before there is a claim brought against the guarantors.
If event of default is not required, that means no reference should be made to the Facility Agreement. Is that right?
No.
No?
Because what is the debt that is actually owed? The debt which is owed by Totora is that which arises from its loan under the facility. The debt which is owed by the guarantors is that which was lent under the facility, and all the guarantee is seeking to do is establishing there is a liability on the guarantees, on the guarantors, that is just as good as the liability as Totora.
So what's the purpose of Article 5? You saying again?
Of Clause 5?
Yeah. Clause 5 of the Guarantee Agreement.
Clause 5 is specifically dealing with a situation whereby if Totora is dissolved as a company,
Yeah.
then any claim against the guarantors can continue.
No, I think I might be wrong. I think maybe another I might refer back to the defendant, to the applicant. What clause you were referring to when you said Serena? What clause you were referring to?
Close to
Clause 2?
the payment.
Yeah. No, there is a clause. You was talking about a clause that you said this is create a full separation between the two documents. But I think it's D4 argument.
6.
Is that 6?
Yes. I think, Your Honor, clauses 2, 6, and 9.
2, 6, and 9. Yeah, I think, 6. It is 6. 6 and 5. So you're saying none of the guarantee agreement clauses, try to make full separation between the two documents?
I say that the two documents are so closely linked as to be parasitic upon each other that the degree of connection is such that any dirham paid by any of the guarantors will partially discharge the debts of Totora, and vice versa, any dirham paid by Totora will partially discharge the debts of the guarantors.
So the full payment of Totora to the debt, is that a full discharge of the guarantee agreement?
And I read that directly from clause 3, that upon Totora discharging debts, the guarantee would just cease to be enforced.
And can we say this will be, for example, if that happens, will be a performance to the guarantee? The payment by Totora is performance to the guarantee agreement at the same time? Or just
it would, I'll refer to the actual language of the guarantee. It would be
discharge.
Satisfaction of or discharge of the guarantee. But it's I've run particular on the words right at the bottom of page 50 here. This is the words at the end of clause 3. Behind the payments by Totora, or any payments by them, don't affect the security until all customer, which is Totora's indebtedness, has been paid and satisfied in full. So the word until there is critical.
Yes, you go on.
So
you want to move to your secondary point?
Yes, those margins in relation to 581B. I'm conscious of time, and I'll move quickly in relation to 582, if I may. But here we have clause 15 does contain an agreement to opt in using specific, clear, and express provisions. I'll perhaps deal first with what the phrase specific, with what the test is for the court to apply. Your Honour was taken to the Suntech case, and I accept that as a perfectly valid authority to look at. This is at tab 6 of Miss Al-Khalifa's authorities.
What do you want me to look at?
If you turn to the top of page 41, you'll see there that we start the page midway through paragraph 11, and the sentence started on the top line, the test to be applied. So we have here a statement by the learned judge that in effect, orthodox contractual principles need to be adopted when analysing a jurisdiction clause. Turning through to paragraph 24, the court here deals with the wording express, specific, clear, or express, and asks itself, well, what does this really add to the analysis? And the court's answer to that is, well, it means that in an ideal world, people should be using the jurisdiction clauses as provided by the registrar in the practice direction. But that in a non-ideal world, the court in fact operates in, the words specific, clear, or express add nothing in addition to the contractual interpretation exercise already carried out by the court. My authority for that, if you look at paragraph 24, one counts down lines 1, 2, 3, 7. 7 lines down, the sentence starting, what is this looking for? And then goes on to in an ideal world.
So what's the point in here?
So the point here is that when seeking to analyse clauses, the court should apply orthodox contractual interpretation principles. That the court should look at the objective meaning of a clause in the context of the contract itself and the wider factual matrix of the contract. The court should entirely disregard.
The applicant says you never mentioned the DFC either in this clause 15 or anywhere else in the document.
Well,
there's no mention of the DFC at all. There is. They said there's no. So you can't find the intention to obtain at all in this, even this document or in the surrounding documents.
My answer to that is that the court cannot place any weight on what Ms. Al-Khalifa says she believes did not believe at the time. The analysis carried out by the court in relation to...
I'm not saying, I'm not addressing the Ms. Khalifa's evidence. What I'm saying, I'm summarizing the applicant's contest to jurisdiction. They said that there is nothing in this case helped the DFC court to come to the conclusion the link can be found anywhere in any document of whether the guarantee, either the guarantee or any other documents. Well, yes. They're saying there is no mention of the DFC court. DFC court is never mentioned.
Your Honor, I accept that that is their case. I say that as part of their case, that they seek to rely on Ms. Al-Khalifa's statement about what she believed at the time. I'm saying in relation to that question, it is irrelevant what she believed because the analysis carried out by the court is objective. In relation to the wider question, as to... So
what is your... I know, when I understand the burden of the applicant to show that the DFC got no connection, but I said, from your side, what is the evidence that the DFC court is about from you? What are you trying to...
Clause 15 is the answer to that.
Say again?
Clause 15
Clause
Is
15.
my direct answer to that. But-
Clause 15 is all about UAE court, and then your choice of any court toward the end of that clause.
Yes. So that
And you saying DFC is one of the UAE? One might say, yo, you mean Ras Al Khaimah court, not DFC court, or Ajman court, or Abu Dhabi court.
So yes, I accept that.
Well, if I can't draw any difference between what you meant, whether Abu Dhabi court, DFC court, or Dubai court, then it's a bit problematic.
Well, you're no, in my opinion. The problem, the power granted under Clause 15 of the contract was that the parties agreed between themselves to set the parameters as to the courts in which proceedings arising out of or related to the guarantee could be brought, and the parameters was it had to be courts of the UAE. Now, as to which court within the UAE,
Yes.
The parties agreed to grant that power to the claimant, my client, as to choose which court within the UAE it wished to bring the proceedings. And if one then looks at Clause 15 itself, one sees exactly this. One sees, first of all, in the setting out of the parameter, and in the next sentence, starting with the phrase "without prejudice," which clearly makes, and not to be construed so as to limit the right of the bank to issue proceedings within these jurisdictions. Now, I accept entirely, as I made clear earlier, that the language of Clause 15 is not as clear as the language contained in the practice direction. But my point to all that is that the language is sufficiently clear to set out the broad parameter that any of the courts of the UAE could be seized as jurisdiction. The power to choose which of those jurisdictions is given to the claimant within Clause 15. And the claimant has exercised that power by choosing this court, by bringing these proceedings as issued under the claim form. So the opt-in it happened through that mechanism.
The opt-in is your choice, isn't it?
Yes and no. So the opt-in was the party's agreement to give my client the power to choose which of the courts of the UAE, and then my client exercised the power.
But isn't this still an ad hoc? It's still ad hoc. There is no intention. You never tell them, I will go to the DFC court. I will sue you according to the common law procedures in the English court and whatever. There is no...
So if Your Honour is asking whether at the time the contract was executed, the court could say with certainty that there had been opting in of the DIFC, then the answer to that is no, and I accept that. What I say instead is that a number of courts, a number of courts were given potential jurisdiction through Clause 15. That the court, that this court was selected then by my client in exercising the power given to it. Now, pausing there, the other way of looking at from the other end of the telescope, if you like, is that this court was always going to be used to bring proceedings against the three guarantors, because under the main facility, and it follows from the terms of those facilities and the legal position of Totora being a DIFC body, a DIFC establishment, that the bank was always going to pick the DIFC to pursue all the defendants.
And you're saying this is a clear opt-in?
Yes.
Can you give me just a second? So you saying this, the third or last statement of clause 15 of the agreement fall under the meaning of specific, clear and express provision of jurisdiction.
Yes.
That's what you're saying.
I do. And if I may just very briefly address the contra preferentum argument before by Mr. Hartridge, he says, well, multiple interpretations can be made of this clause, and therefore...
Can we draw, let's say, distinction between what's exactly clear? Clear is your choice, or clear reference to the DIFC court?
What I say is clear is, yes, it's that there is the choice of jurisdiction, looking at the guarantee of the whole.
Yes, this is the clear, yeah. This might be clear for me, I would say.
Yes,
it's clear you have given maybe the choice to sue, whereas. And your performance of the choice is just which parties to be bound. Why?
Yes, so what I say is expressly set out in clause 15 is that my client is given a power that is not given to the defendants, to the guarantors, to make a choice as to which of the courts of UAE it brings the claim within. Now, on a broader analysis, that the power supposed to be granted to my client is only has no real breadth at all, because that power can only properly be exercised by bringing things in this court, in this jurisdiction, due to the position of the Totora. So that is a route I see through as to how 582 is relevant and how we have opted in.
Yes.
Okay. Your Honour, as Your Honour will gather, my primary argument is that we succeed under 581B. My fallback argument is 582. My further fallback argument is the contractual estoppel one. I don't know the extent to which Your Honour is familiar with the case of Springwell and whether it should assist Your Honour in me briefly taking you through the relevant parts of that case.
Yes, please go on.
So the principle. The case is in the authorities bundle at tab 3.
You sure? It's not 3.
Excuse me, it's part 2 of the authorities bundle, tab 3. And you all should see there the page number.
You're referring to Ms. Khalifa's authority bundle?
I'm referring to part 2 of the bundle. I believe it's all in the same leverage file. But you should see that the tab numbers start from 1 again. So in my bundle there's a yellow tab after which the about midway through the bundle, and then everything restarts.
The yellow tab is number 4. Is that right? So I'm looking at application hearing bundle of fourth. Oh, this is the fourth defendant. Sorry.
So certainly not the application hearing bundle.
That is the fourth defendant.
My one is headed Bundle of Authorities.
This one.
So if you're on a, you should see there are tabs 1 to 7, and if you go all the way to tab 7, first of all, you should then see immediately behind that. Your old version is orange.
I have orange one, yeah,
yes.
the one, yeah.
So then go through the orange, and then it's tab 3 after that. And there should be there the front page of a case called Springwell Navigation.
Yes, I see it. Yes.
JP Morgan.
I mean, no. Yes.
Now, I don't proceed through all this judgment. It's a very lengthy judgment.
I can see
issues which are not relevant at all for our purposes.
Right.
If you turn through to page 68
of the bundle,
yes, within that tab, you'll see here towards the bottom of the page, paragraph 141.
Yes.
And the words in italic, what was called in that case the lower long-back issue, in the middle of that paragraph, the words in italic are the relevant contractual clause. The court was there looking on it. It's a standard form non-reliance clause. And in very brief terms, the argument being run in that case was that due to that clause, then even though there was actual reliance by the claimant on representations made by the defendant, the claimant was not able to rely on those representations by reason of that clause. Turning over the other page, page 69, the principle is defined at paragraph 143. If you look there at the second sentence of paragraph 143.
Unless?
Starting, I will try and analyse the matter from principle. If A and B enter into a contract, then, unless there is some principle of law or statute to the contrary, they are entitled to agree what they like. There's then an analysis of...
but is this about jurisdiction or just a general term of contract? This is about contract in general, isn't it?
Yes, it's about contract in general, about the issue of contractual estoppel, which then will bring back eventually to the jurisdiction argument. So we, Court of Appeal then looked at a number of cases and pointed out that some cases had taken a wrong route. They then talked about the correct route, and the questions posed themselves at paragraph 145. What therefore does lower non-bank actually decide?
Where are you reading now?
So I'm at paragraph 145.
Yes.
You see that this is a question posed by the court.
Yes.
But then go on to answer that in some detail. The next passage I'll take you to is passage paragraph 154. Where the case of Lord Justice Chadwick, who of course subsequently became a judge in this jurisdiction, had analysed this type of clause and called it an evidential estoppel. And the phrase they used by the learned judge, I say it's important in terms of applying this back eventually to the Gateway 5A1B as opposed to Gateway 5A2. And that paragraph 156, the principle is again summarised and stated by the Court of Appeal, the first sentence of paragraph 156. I'll refer you on to. That's at page 73.
Yes.
So, bringing that point to an end, the proposition I derive from that section of the case is that the parties can agree between themselves for matters to be seen evidentially as X, even if both of the parties accept them to be Y. Now, in this case, I say that the parties agree between themselves for the contract, for the guarantee to be treated as if it was signed in the DIFC, even if they both knew, in fact, it was being signed outside the DIFC. And the parties are at entire liberty to reach such agreement within the contract, within their autonomy granted to them under contract. The subsidiary question for the court in the Springwell case was whether or not there was any second step, because you all will be familiar with most estoppel situations where you first of all need the first stage, and you need the second stage being whether it's unconscionable to move beyond it, and a sense of conscionability. And the answer to that was given at paragraph 177 of the Springwell judgment, where they said there is no second look to this type of test.
You said 177?
177.
Yeah.
If you look at 1, 2, 3, 4,
Yes.
5, the sixth line down of paragraph 177, where the learned judge says, to my mind, once it is accepted that there is a separate doctrine of contractual estoppel, then there is no room for a requirement that the party which wishes to rely on that estoppel must demonstrate that it would be unconscionable for the other party to withdraw from the conventional state of affairs.
Well, this might be like in general valid, but I mean, the problem which I see, party cannot go beyond jurisdictional barriers, because usually the court jurisdiction defined in different ways, found in different ways, in different agreements, certain court. If I would like to put the DFC jurisdiction aside, because it's a bit unique, as it's, at least in this region of the world, that it's accept opt-in. But if the choice is not DFC, then what you are talking about would be like pointless, because you can, in my opinion, you can't argue this before Dubai court or Abu Dhabi court, because they don't have what's called an opt-in issue things, unless the opt-in is a departure from the DIFC. This is the only case, in my opinion, that Dubai court would accept. But if you talk to Abu Dhabi court, as Khaim or Sharjah court, they said, well, what I choose your court. We said, oh, well, it's not about your choice, because we will go and look at our jurisdictional rules, and we will see whether your case falls under our jurisdiction or not, with reference to the Civil Procedures Code. So parties' choice won't be. And this can happen not just in UAE and in many other jurisdictions, worldwide even. You know what I mean? So I think this is one of the problems that are facing your argument.
Well, what I'm doing by relying on the Springwell case is I'm addressing directly the applicant's position. The applicants say, we signed the guarantee outside DIFC, therefore the guarantee was not finalised or executed in the DIFC, therefore Article 5A 1B is not engaged. Those are their logical steps. I say, well, where you actually signed the guarantee does not matter, because under the guarantee itself, the parties agreed to be treated as if they signed the guarantee within the DIFC, so that it was that evidently the court concluded.
This was in the recital of the agreement or any of the operative clauses?
It comes from. Yes. I'm in the guarantee. I'm at page 53 of tab 2,
Yes.
Towards the bottom of that page, you'll see in witness whereof this guarantee has been executed by the guarantor, the place and the date first written above.
So this is not an operative part of the contract. This is only recited, is that right?
Yes. Well, I say it's not operative. I say it has force as establishing the contractual estoppel between the parties. So it's reliable to that extent. The language there as to what place is being referred to, the court can look at it a number of different ways. The way I would prefer, or I myself look at it, is that it is seen as part of the signature aspect of the guarantee, so that when it says the place and date first above written, it's in fact referring to the addresses cited with 3 times. Sorry, excuse me. The address cited then just below where it says the guarantor, because you'll see there that Mr. Ramadan in this one states his address is in fact Totora's address in the DIFC.
And with
Same for Mr. Khalifa.
what if I say this conflicts with Article 15 above? No, just academic question.
Yeah. Well, so my answer is that there is no conflict. If there is tension, that tension force to be resolved by the court in its exercise of interpreting the contract. So what I say is that the court can look at, as I say, a number of different parts of the contract as to where you see the place in question. My preferred view is to look within the signature section, hence at the bottom of 53. The court could alternatively look at the place cited at the top of page 50, and there the address in question is again the IFC.
Yes, I see your point on this.
I should say for completeness, though I don't accept Ms. Bosham-Barber's argument that the court should look at even higher up and say, well, Commercial Bank of Dubai, branch Maine, and then carry out some research, and then from there reach a conclusion as to where the place in question is. I say that this point should be resolved within the contract itself, and that's what's being achieved there. So you want to, those are my submissions on in relation to the third limb of the application.
Yes, next.
I think that in my submission I've already dealt with the Khalil case and the Suntex references made by the applicant against me. Your Honour, I think that the final point to make is just that Your Honour will have seen in my skeleton argument a reference is made to the outstanding request for default judgment, and that's something that the bank doesn't pursue further at this stage. We set the clear terms of the Rules of Bank Law Part 13, and that we have defendants here who are defending the claim. But we're saying that the reason for the IC not agreeing to enter default judgment, not granting request made by my client, again supports our argument of jurisdiction. It all comes back to the fact that we are pursuing Totora in this court. This court is the right and only court for us to pursue Totora in. And the guarantor, the claims against guarantors, should and must be heard together. And it simply not make sense and a multiplicity of actions on the same issues in the same courts. And would be wrong in principle to do so. Well, those are my submissions, unless you have any questions for me at this stage.
Yeah, you see, as I said, I would go with you. I mean, academically, I would go with you in your submission that there is a strong connection. But can I ask you this question? Let's presume you have not sued Totora at all before the DFC. For any reason, you believe it has no assets, no point suing Totora at all. Can you, based on the guarantee agreement itself, sue any of the defendants directly?
Yes.
Further on? Yes.
So the answer...
without the need of suing Totora?
Correct. The answer for that comes from clause 1 of the guarantee, under which the terms of the facility are inherited, and we therefore through that get this very close link to this jurisdiction. And we have, it goes back to my very first submission of the phrase "a contract" in Article 5A1B. I don't need to sue under the facility in order still to rely on the facility as being the contract.
Well, your answer is you still can sue Mr. Khalifa or Mr. Rafai or the first or the second defendant separate without the need of suing Totora from the beginning.
Yes.
You can still have very good arguable case or good cause of action against any of the defendants in separation from the first defendant and in separation from the facility credit agreement.
So it is correct that my cause of action against each of the 4 defendants is severable. It is not correct that...
Well, I understand your worry, yeah, but the answer is yes. You can sue, for example, D4 or D3 and independence from Totora.
Yes. Yes.
With a separate cause of action. And,
exactly.
Right?
I can sue, also I'm speaking on behalf of my client here, can sue any of the 4 defendants alone or jointly. Or I can select arbitrarily which of them to pursue. But in any of those cases...
But I do want to go on and ask you if you can sue each of them in different jurisdiction or not, because I would think you would say no.
Yes, exactly. That's exactly what I'm going to say.
The first answer
is that this is the only court on which to pursue them due to the operation and the relationship between the facility and the guarantee.
You done? Well, I thank you. Thank you very much for this. Well, I think we are behind time. I believe I heard enough from all parties. Unless D3 or D4 wants to make a very important point for a minute or maximum 2, then we come to the end of this hearing. You done?
Could I just make one point which seems to be fairly glaring in what I hear from my learned friend? He says that the DIFC court is the right and only court in which this case can be conducted. He says that the bank has no option other than suing in the DIFC court. We're talking about suing Totora as the filing. But in fact, when you read the jurisdiction clause in the facilities agreement, and again, we're not arguing from our point of view this facilities agreement, there is no exclusive jurisdiction. This is a big difference between this jurisdiction clause and the guarantee clause, equivalent clause. There's no exclusive jurisdiction, so this case can be taken in any of the courts of the UAE. And it seems that my learned friend is saying, on the one hand, the courts of the UAE include the DIFC courts, but in the guarantee, there was a right to select any court within the DIFC, which right only came to the claimant on the basis of the last sentence of clause 15. But the last sentence of clause 15 says that this right, which I've already commented on earlier as to whether it's valid or not, is to take proceedings against the guarantor in any other one or more jurisdictions. So this purports to give the claimant the right to look outside the UAE courts and therefore outside the DIFC on the basis that they accept that the DIFC is part of
Other as opposed to UAE, you mean?
Yeah, absolutely.
Not other as opposed to one.
No, exactly. Other as opposed to UAE courts,
Not
includes...
Not as opposed to one. It can be one and another, or UAE or another court.
Yeah.
So you're saying the option extends to give the choice for him to go beyond the United Arab Emirates jurisdiction.
So the argument we see, my seems to be making is that they have no choice. They have to come to the DIFC to sue the restaurant, and therefore, in the natural course of events, or however they wish to describe it, the guarantors have to also be dealt with by the DIFC.
Yes.
Is not that.
No, when he said I have no choice but to come to the DFC, he said because I'm suing Totora, which is located in the DFC, and this is linked one way or another to the Totora case. So then I have no choice but to come here. That's what he said.
The fact that my response to that would be that the fact that the DIFC...
He didn't say I just selected DFC for no reason. He said I selected DFC because it's completely related to the Totora, and then the contract with Totora, with the credit facility agreement, and then the guarantee agreement are linked one way or another. This is the way I summarize his difference.
Yes, I heard differently.
I know the difficulty you facing taking into account his argument. But
I mean, when he says clearly they have no option but to come before the DIFC, I don't see there that there's been a selection. He's saying that they have no option to come before the DIFC because Totora is a DIFC entity, which of course is a non sequitur and clearly not provided in the
well, I'll see your concern. Yes, thank you very much.
If I may, Your Honor, I would like to address only one issue, very minor, and briefly. The claimant just stated that Ms. Al-Khalifa is stopped from pursuing the argument that the guarantee was signed outside of the DIFC and relies on the English case Springwell. We submitted that Springwell doesn't apply in this case. Springwell is a claim for contractual misrepresentation, does not deal with jurisdiction. In Springwell, the agreement contained a number of provisions to the effect that the bank had not made any representation and that the claimant that was in that case a sophisticated investor had not relied on any representation made by the bank. The investor claimant in Springwell later claimed that the defendant had made misrepresentation that the claimant relied upon in entering into the contract. And the Court of Appeal held that this provision contractually stopped the claimant investor from contending that there were any actionable representation made by the bank and precluded the claimant investor from reliance on them. We submit, Your Honor, that this is a completely different context. In this case, the parties are not on equal bargaining power, and therefore Ms. Khalifa is not limited in any way by this type of clause, and estoppel simply doesn't apply in this case.
I see what.
Thank you.
But as I said before, I have heard enough about these applications. So the case is reserved for judgment and cost. Thank you very much.
All rise.